Hi friends, my name is Chris Iverson, and I'm a pro-life advocate in the Chicagoland area. Today we're having a pro-life event in Aurora, Illinois, and recently I've been watching some videos by Supreme Court justices about Roe v. Wade and related issues of jurisprudence. And their responses about Roe v. Wade and abortion and the role of the court. Should the court be making laws, for example? And under what circumstances should a precedent like Roe v. Wade be overturned? Have been very interesting and are different substantially from what you typically hear in the political realm. So I hope that you'll find value from these quotes and these clips I've taken from these different videos of Supreme Court justices. Thanks.
I wanted to bring up this famous story between two long ago legal titans who had had lunch, Judge Han and Justice Holmes. And as Justice Holmes left the lunch, Judge Han said, "Do justice, sir, do justice." And Justice Holmes stopped his carriage and said, "It's not my job to do justice. My job is to apply the law." Justice Breyer, are you Holmes or Hand?
I'd be very happy to be either one. And the short answer is when we have cases, we try to apply the law and get the right answer in the case. And of course, we both think, I believe, that ultimately the point of law is to satisfy a human desire that's probably 10 or 20,000 years old. That people, of course, want justice. Justice, justice shall you pursue. And they want it, and they expect, ultimately, that the law will help them achieve that very basic and noble end. And we understand what the basic end is, but we also think, or at least I do, and I'm sure Justice Scalia does, that you don't necessarily get to that end simply by trying to look for what is the intuitively nicer result in each case. So we're there to apply the law, but we don't forget what the ultimate objective is.
Of course, I don't particularly buy into the Holmes philosophy totally anyway, and I think that's a false choice. I think that's just a false dichotomy. You can have law plus justice. The whole idea of what appellate work is and what district courts do. When you have a problem that hasn't been resolved yet, you fill in the gaps. And you can do it one of two ways. You can look at every case, in which case you have no principles, or you can have a principle in which you're making law. This is a horrible make law. But when you do so, you should do so with the idea of justice.
If people agree with Holmes and do not want their judges to simply apply their own notions of what's a good rule, but rather to follow as best they can what the people have decided through the Constitution and through the statutes. If that is the case, it follows that you cannot judge a judge simply on the basis of whether you like the outcome of the case, which is normally all you're going to find in a newspaper report. You're not going to find the textual gymnastics that the judges had to go through to reach the result. You're going to see, did the good guy win, did the bad guy win? And you're inclined to say, if the good guy won, wonderful judges, and if the bad guy won, terrible judges. That's not true, unless you believe that every statute ever written produces a sensible result. But, you know, the ideal rule for the honest judge is garbage in, garbage out. You are supposed to interpret the statutes reasonably, even if you don't agree with the result, because it's not up to you to decide what's garbage. And if you bear that in mind, you should be what should I say, more careful to either praise or criticize judges just because you like the outcome or dislike the outcome of their cases.
I suppose morality and rights is what's behind our whole conception of our Bill of Rights, behind the contemporary human rights documents in the United Nations, in Europe, all over. Isn't that a reflection of morality? I think so.
Does natural law have a place in interpreting the Constitution?
No? Look, it says what it says. I apply United States law. I don't apply natural law. God applies natural law. The only... Now, natural law has a place in writing law. When you're writing a constitution or when you're writing a statute, you should not put in that anything that you know or believe is contrary to natural law. But once it's in there, it says what it says. And if it forces me to do something that's against my conscience, of course, I have to resign from the bench. But the mere fact that it doesn't conform to natural law, but that does not cause me to be doing anything evil, that's no basis for me saying, oh, the statute doesn't conform to natural law, so I'll apply the natural law. No, that's... The only role natural law has under the Constitution is, did you mention the Ninth Amendment in one of your earlier questions?
I did. Well, Justice Blackmun mentioned it.
Yeah, Justice Blackmun did. Well, that's the amendment that says the enumeration herein of certain rights shall not be deemed to deny or disparage other rights that are retained by the people. And academia in recent years, having finally yielded to the reality that substantive due process, which has been the basis for Roe versus Wade and a lot of the living Constitution nonsense, having finally conceded that that doesn't make any sense, they're looking for other ways to get there, and one of the ways is the Ninth Amendment, which is a source of unenumerated rights. It isn't a source of unenumerated rights. I apply the Ninth Amendment. I apply it rigorously. I do not deny or disparage other rights. Maybe there is a right to abortion. That's not my line of territory. You're free to argue to the legislature that there is. But I know that it's not one of the rights contained in the Bill of Rights and therefore not one of the rights that I enforce. What the Ninth Amendment was the expression of the framers' belief in the natural law. Just because we have a few rights here doesn't mean that there aren't any others. And if you try to take them away, we'll be back on the barricades. That's what it meant.
But let's suppose that a woman in 1971 is prosecuted for having had an abortion in the state of Alabama. And she raises the defense that she had a constitutional right to have an abortion. And that case, let's suppose, came to the Supreme Court in lieu of Roe. And you were a justice at that time.
You're presupposing that she's going to be prosecuted. Which
I'm presupposing.
I think it's an unlikely
we could have the doctor prosecuted.
Yes, the doctor.
Okay, the doctor would be
ordinarily it would be the doctor.
Okay, if you prefer the doctor, that's okay.
But it's okay. You want to make it.
I was trying to make it the most dramatic and easy case, but.
Yeah. The doctor is a harder case because of medical regulations about safe and sanitary conditions.
But the state just says any doctor who performs an abortion goes to jail.
Yeah.
So if you were on the court and that was the case that was presented, how do you think you would have ruled back in 1973?
But with the hindsight, with Roe as the precedent,
No Roe. Clean slate.
Why do you think that case is different from what was the Roe case of a woman who was pregnant, and there were a few plaintiffs there. There was a doctor, all arguing to have the state of Texas law declared unconstitutional. Why should there be any difference between the response to the woman who was being prosecuted for having had an abortion or Roe? I think they would have come out the same way because, as you pointed out, Roe was a 7-2 decision. It wasn't controversial at the time.
Segment 4, how it should be done and how it should not. How it should not. Roe versus Wade. Two quotations. Reading law. In Roe versus Wade, the Supreme Court declared unconstitutional state statutes that in no way contradicted any specific provision of the Constitution, close quote. Second quotation, Justice Blackmun, 1973 opinion itself. The right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty or as the district court determined in the Ninth Amendment's reservation of rights to the people is broad enough to encompass a woman's decision whether or not to terminate her pregnancy, close quote. So Justice Blackmun, writing for the majority, takes pains to ground the court's decision, well, I suppose you could, in the 14th and the 9th, or if you read his opinion carefully, it's the 14th or the 9th. You get to choose. And he's wrong.
Did he say the 14th? Or
he said
did he say
the right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty, as we feel it is, or as the district court determined in the Ninth Amendment's reservation of rights to the people.
Well, once again, this is one aspect that the book addresses. When you have terms in the Constitution that are not ambiguous in the sense that they can mean one of two things, but rather are general, so that they could cover a lot of things. You should interpret them not to cover the things that the people who adopted that provision did not think they covered. And, you know, cruel and unusual punishments is one. Of course, those words could cover a lot of things, but it's clear from the history of the times that nobody thought that it included the death penalty. Nobody. And it's the same thing with this right of abortion, whether it's founded in the 14th or, I mean, God, the Ninth Amendment, forget about it. Nobody ever thought that, I mean, just look at history. All the states had prohibitions on abortion for hundreds of years. So when was it that the American people made the decision to forbid a state from adopting such?
They never did.
They never did. The court made it up. And you know, we're not talking about the right or wrong of the substantive result. I mean, I'm quite, you know, neutral on that. The point is, who should decide? Should it be a question on abortion, whether people try to persuade each other that there ought to be, there oughtn't to be, and put it to a vote? That's fine. That's, you know, if you want the right to abortion, create it the way most rights are created. In a democracy, you persuade your fellow citizens, pass a law. You want to abolish the death penalty, the same thing. But all of that democratic choice is taken away when the court is enabled to give vague provisions such as due process of law, equal protection of the laws, meanings that they did not have when they were adopted.
What I'm trying to get at, though, is simply, if you were on the court at the time of Roe, right, how would you have voted? Any variations of the cases is fine.
I would have said this most extreme law is unconstitutional. Texas allowed abortion only to save the life of the woman. She could be left totally debilitated, and it wouldn't matter. She could have been the victim of rape or incest, and it wouldn't matter. The only thing was her life. That was too extreme, and I think it would have been quite easy for the court to rally around a decision that said, stacking the deck against the woman that way is just too far to go. My notion was that if the court, instead of covering the country so that every abortion law, even the most liberal, did not measure up to the court's decision, had simply writ small, had said this most extreme law is unconstitutional. Then the change that was occurring in states, like my home state, was one of the, in the early 70s, was New York, California, Hawaii, and I think Alaska.
Alaska.
If a woman could travel to one of those states, she could have a safe abortion.
Well, the doctrine of stare decisis, which is a doctrine of precedent, is a very important part of American law and of the way the Supreme Court does its business. And it doesn't mean that one can never reverse a case that has been decided and that one thinks is wrong. But it does mean that actually you need to be able to say more than that it's wrong, that if all it takes is to reverse a case is to think it's wrong, then the doctrine of stare decisis doesn't mean anything. And there is a pretty well-developed law about what else you need to be able to say about a case to reverse it. And you don't need necessarily to say the same things about every case, but you need to show that something like that the case has proved unworkable, or that its foundations have been undermined by subsequent changes in the law or by subsequent changes in society. You need to have an account of why it's appropriate to reverse a decision that goes beyond your view that the decision was decided was incorrect the first time around.
And I begin collaterally with the issue of stare decisis and the issue of precedence. Black's Law Dictionary defines stare decisis as let the decision stand, to adhere to precedents and not to unsettle things which are established. Casey had this to say in a rather earthy way. People have ordered their thinking and living around Roe. To eliminate the issue of reliance, one would need to limit cognizable reliance to specific instances of sexual activity. For 2 decades of economic and social developments, people have organized intimate relationships in reliance on the availability of abortion in the event contraception should fail. That's the joint opinion, rather earthy in its context. Would you agree with that?
Well, Senator, the importance of settled expectations in the application of stare decisis is a very important consideration. That was emphasized in the Casey opinion, but also in other opinions outside that area of the law. The principles of stare decisis look at a number of factors. Settled expectations, one of them, as you mentioned, whether or not particular precedents have proven to be unworkable is another consideration on the other side. Whether the doctrinal bases of a decision have been eroded by subsequent developments. For example, if you have a case in which there are 3 precedents that lead and support that result, and in the intervening period 2 of them have been overruled, that may be a basis for reconsidering the prior precedent.
But there's no doctrinal basis erosion in Roe, is there?
Well, I feel the need to stay away from a discussion of particular cases. I'm happy to discuss the principles of stare decisis.
So, okay, so basically, one question in Roe is if the court was going to invalidate the law, how broadly would it do so? So what Justice Ginsburg has suggested is that from her perspective, at that moment, the right decision would be a very narrow decision, which would have said the Texas law that was actually at issue in the case, which prohibited any abortion except to save the life of the mother, is unconstitutional, and we don't have to decide whether any of the other restrictions are permissible.
What I had difficulty understanding at the time, Jeff, is here is Sally Reed's case. Sally Reed is a woman from Boise, Idaho. Her young teenage son died under tragic circumstances. She and her husband were divorced. The boy died when he was in the custody of his father. Sally wanted to be appointed administrator of his estate, and the law of Idaho at the time said, as between persons equally entitled to administer a decedent's estate, males must be preferred to females. Just that clear. It was a perfect first case. But here is Reed at the court, and the court writes very small, as you said. This is an irrational classification. And at the same term, it decides Roe v. Wade in a stunning opinion that makes every abortion law in the country unconstitutional. So Reed said, this most extreme law is no good. But Roe said, any restraint, we're going to do the whole job all at once. No, in the first trimester, no restrictions. In the second trimester, restrictions in the interest of the health of the woman. That they wrote this entire charter to cover the waterfront, where in Reed they wrote so small. I couldn't understand why the justices in that very same term took such a different view of how far and how fast the court should move.
But I think it is fair to say that you are the justice who is most willing to re-examine the court's precedents and reconsider.
Because of my affinity for stare decisis.
Well, that's what I was going to ask you about. Stare decisis doesn't hold much force for you.
Oh, it sure does, but not enough to keep me from going to the Constitution.
Well, I have various three principal factors that I take into account for stare decisis. How wrong was it? Some of them have just been maliciously wrong, really bad. And Roe versus Wade, even the people that like the outcome acknowledge it was a lousy opinion, that substantive due process was terrible and doesn't really bring you there. They've abandoned the opinion, though not the outcome. Factor two, how well accepted has it been? Well, something like the incorporation doctrine. The law students are here. That's the doctrine that the post-Civil War amendments, the 14th Amendment, in effect, applied the Bill of Rights to the states. The Bill of Rights didn't originally apply to the states. It begins, Congress shall make no law. Nobody thought it applied to the states. But for the last 50 years, the court has been proceeding on the assumption that the 14th Amendment incorporated it. And, I can live with that. It's been well accepted. Contrast that with Roe versus Wade. Controversial when it was announced, remains controversial. And thirdly, and for me probably the most important, does that prior opinion, does the principle that prior opinion establishes permit me to behave like a judge, which is to say, behave like a lawyer? And Roe versus Wade, or in its reincarnation, Casey, which said we will never overrule it and then proceeded to overrule it, the principle of Casey is that a statute is unconstitutional if it places a, quote, undue burden on the woman's constitutional right to an abortion. What am I supposed to do with that? I'm a lawyer. I run to the law books. What do you know? For 200 years, no burden was an undue burden. I certainly can't use that. What do you think we're going to talk about the next time we have a case? Let's say a case that requires a certain staffing of abortion facilities, so many doctors, so many nurses, very expensive equipment, causes the price of abortion to go up. The issue is, does this place an undue burden on the Constitution? What are we going to talk about? I assure you the conversation will go something like, so many doctors, so many lawyers. I don't think that's an undue burden. You think it's an undue burden? How many think it's an undue burden? 5 hands it is, 4 it isn't. I'm not going to do that. That's not law. I do not mean to denigrate the importance of the question. Yes, it's an important question, and somebody ought to make that call, but it's not a lawyer's call. It's a call for legislators. They vote on policy stuff like that. It's not law. So let the legislatures do it. Anyway, that's why I consider that over the edge and don't accept stare decisis for that stuff. I can't do it.
So basically, Justice Ginsburg has offered 2 critiques of Roe. One of them is that the court went too far. It should have been much more modest in what it invalidated. It should have invalidated the Texas statute and not gotten into all the other questions that the opinion got into about the first trimester and second trimester and when the state can regulate abortion and when it can't regulate abortion. It should have simply said it's unconstitutional for the state to prohibit abortion except to save the life of the mother, and we don't decide anything else about what other restrictions might or might not be constitutional. Leave that for another day. And whereas the court, interestingly, given that it was 7 Republican-appointed justices and 3 of the 4 Nixon justices, was extremely activist, right? This was a very activist opinion. And so that's one criticism. And the other criticism is that the court wrote an opinion that was less focused, indeed not at all focused, on what Justice Ginsburg believes should have been the core issue, which is the rights of women to control their own lives, and instead writes this opinion in much more, in ways that are removed from that as the core question. But let's look at because I know one of the things you've said many times, and including recently, is that it mattered that Roe went as far as it did in a negative sense. It's not just that, as a matter of taste, you would have rather have seen the court be incremental rather than bold, but rather that we have paid a huge price because the court made the decision to be that activist, that aggressive, that bold in taking on the entire issue of abortion, as opposed to writing a much narrower opinion with a much more limited effect. So I think it would be interesting for you to talk a bit about how you see the effect of the Roe decision on the polity and on what's happened in this country over the last 40 years.
Roe became a symbol, I think, for the right to life movement. There's an annual parade in D.C. On the day that Roe was decided, January 20-something. They had a single target to hit at. This decision, this most undemocratic decision by 9 justices who nobody elected to make policy for the country. That charge, that what a great organizing tool it is. You have a name, you have a symbol, Roe v. Wade, you can aim at that. This decision was made not in the ordinary democratic process, but by these 9 unelected men. I know that Reva Siegel and Linda Greenhouse have written persuasively about the anti-abortion movement began before and it continued after, and Roe didn't cause this backlash. But I think there's no getting away from the presence of a single target to aim at. How often has the name Roe v. Wade been the center of the opposition? That was my concern, that the court had given the opponents of access to abortion a target to aim at relentlessly, and attributed it not to the democratic process, but to 9 unelected old men, that choice to make. So that was my criticism of Roe, is that it seemed to have stopped the momentum, which was, and the momentum was on the side of a change. And I made a comparison in this country between no-fault divorce and access to abortion. When I was the age of most people here, in my home state, there's only one ground for divorce: adultery. Inside of 10 years, every state in the nation had changed to some form of no-fault divorce. And I envisioned that there would be a similar thing with abortion. There'd first be states like New York that said at least in the first trimester it's up to the woman. Then there'd be the states in between following the ALI model. Maybe the ALI, in light of the changes in the country, would change its position. I expected much more back and forth, much more dialogue among people who play in the political process. That's what that would have been my ideal picture of how this issue would have gotten resolved, instead of having the Supreme Court as the single decision maker. And of course, the history of the years since then is that the momentum has been on the other side. The cases that we get now on abortion are all about restrictions on access to abortion and not about expanding the rights of the woman.
The joint opinion then goes on after the statement as to sexual activity to come to the core issue about women being able to plan their lives. Quote, the joint opinion says, the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. Do you agree with that statement, Judge Roberts?
Well, yes, Senator, as a general proposition, but I do feel compelled to point out that I should not, based on the precedent of prior nominees, agree or disagree with particular decisions, and I'm reluctant to do that. That's one of the areas where I think the prior nominees have drawn the line when it comes to, do you agree with this case or do you agree with that case? And that's something that I'm going to have to draw the line in the same place.
Well, I'm not going to ask you whether you're going to vote to overrule Roe or sustain it, but we're talking here about the jurisprudence of the court and their reasoning. Let me come to another key phase of Casey, where the joint opinion says a, quote, terrible price would be paid for overruling Roe.
I do think that it is a jolt to the legal system when you overrule a precedent. Precedent plays an important role in promoting stability and even-handedness. It is not enough, and the Court has emphasized this on several occasions, it is not enough that you may think the prior decision was wrongly decided. That really doesn't answer the question, it just poses the question. And you do look at these other factors, like settled expectations, like the legitimacy of the Court, like whether a particular precedent is workable or not, whether a precedent has been eroded by subsequent developments. All of those factors go into the determination of whether to revisit a precedent under the principles of stare decisis.
It guarantees that there is a fundamental constitutional right to privacy as it applies to contraception. Do you agree with that? In your opinion, is that settled law?
That is the precedent of the court, so it is settled law.
Is there a general constitutional right to privacy, and where is the right to privacy, in your opinion, found in the Constitution?
There is a right of privacy. The court has found it in various places in the Constitution, has recognized rights under those various provisions of the Constitution. It's found it in the Fourth Amendment's right and prohibition against unreasonable search and seizures. Most commonly, it's considered, I shouldn't say most commonly because search and seizure cases are quite frequent before the court, but it's also found in the 14th Amendment of the Constitution when it is considered in the context of the liberty interests protected by the Due Process Clause of the Constitution.
All right. Judge, the court's ruling about the right to privacy in Griswold laid the foundation for Roe versus Wade. In your opinion, is Roe settled law?
The court's decision in Planned Parenthood versus Casey reaffirmed the core holding of Roe. That is the precedent of the court and settled in terms of the holding of the court.
Starting with the woman's right to choose, Judge Alito, do you accept the legal principles articulated in Griswold versus Connecticut that the Liberty Clause in the Constitution carries with it the right to privacy?
Senator, I do agree that the Constitution protects a right to privacy, and it protects a right to privacy in a number of ways. The Fourth Amendment certainly speaks to the right of privacy. People have a right to privacy in their homes and in their papers and in their persons, and the standard for whether something is a search is whether there's an invasion of a right to privacy, a legitimate expectation of privacy.
Specter then brought up the often cited letter Alito wrote in 1985 in applying for a job in the Reagan White House, stating the Constitution does not protect a right to an abortion.
Do you agree with that statement today, Judge Alito?
Well, that was a correct statement of what I thought in 1985 from my vantage point in 1985, and that was as a line attorney in the Department of Justice in the Reagan administration. Today, if the issue were to come before me, if I am fortunate enough to be confirmed and the issue were to come before me, then I would approach the question with an open mind, and I would listen to the arguments that were made. So you would approach it
with an open mind, notwithstanding your 1985 statement?
Absolutely, Senator. That was a statement that I made at a prior period of time when I was performing a different role. And as I said yesterday, when someone becomes a judge, you really have to put aside the things that you did as a lawyer at prior points in your legal career and think about legal issues the way a judge thinks about legal issues.
Specter noted that the 1973 Roe v. Wade decision affirming a woman's right to an abortion has been reaffirmed 38 times, and asked if it fell in the category of stare decisis, the principle stating that precedent decisions are to be followed by the courts.
When a precedent is reaffirmed, each time it's reaffirmed, that is a factor that should be taken into account in making the judgment about stare decisis. And when a precedent is reaffirmed on the ground that stare decisis precludes our counsels against re-examination of the merits of the precedent, then I agree that that is a precedent on precedent. Now, I don't want to leave the impression that stare decisis is an inexorable command, because the Supreme Court has said that it is not. But it is a judgment that has to be based taking into account all of the factors that are relevant and that are set out in the Supreme Court's cases.
Toward the end of his round of questioning, Specter asked Alito to explain his dissent in the 1991 case of Casey versus Planned Parenthood, in which the Third Circuit Court of Appeals struck down a Pennsylvania law that included a provision requiring women seeking abortions to notify their spouses.
I did it because that's what I thought the law required.
But Wisconsin Democrat Herb Kohl pressed Alito on Casey.
Judge Alito, in Casey you argued that the requirement that a woman notify her husband did not impose an undue burden upon a woman. You reasoned in part that the number of married women who would seek an abortion without notifying their husbands would be rather small. In other words, only some women who would be affected. The majority in that case disagreed with you and stated, quote, whether the adversely affected group is but a small fraction of the universe of pregnant women desiring an abortion seems to us irrelevant. The issue, unquote. This disagreement begs the question, is a constitutional right any less of a right if only one person suffers a violation, or should greater value be placed on that right if a larger number of people have that right violated?
Part of the problem was that the law just was not very clear at that time. The undue burden standard had been articulated by Justice O'Connor in several of her own opinions, and there were just a few hints in those opinions about what she meant by it. But what she said was that an undue burden consisted of an absolute obstacle or an extreme burden. Those may not be exact quotes, but they're pretty close. And she did say that it was insufficient to show simply that a regulation of abortion would inhibit some women from going forward and having an abortion. That was the information that was available in her opinions to try to understand what this test meant. And so then the question became, how do you apply that to the numerous provisions of the Pennsylvania statute that were before us? And it was a difficult task. The plaintiffs argued that all of the provisions constituted an undue burden, and when the case went to the Supreme Court, Justice Stevens agreed with that. He said they all were an undue burden. Things like a 24-hour waiting period, that was an undue burden because it would inhibit some women from having an abortion. An informed consent provision. Justice Stevens thought, and the plaintiffs argued, that would be an undue burden. The majority on my panel and the joint opinion on the Supreme Court found that most of the provisions of the statute did not amount to an undue burden. The 24-hour waiting period, the informed consent provision, and all of them. We disagreed on only one, and that was the provision regarding spousal notification with a safety valve provision there, that no sort of notification was needed if the woman thought that providing the notification would present a threat of physical injury to her. And it was, I wrestled with that issue, but based on the information that I had from Justice O'Connor's opinions, it seemed to me that this was not what she had in mind. Now, that turned out not to be a correct prediction about how she herself would apply the undue burden standard to that statutory provision, But that was the best I could do under the circumstances.
No, I did not say it should have been left to the democratic process. I suggested that it would have been healthy if there had been a dialogue, just as there was in the gender discrimination cases. In that decade of the 70s, wasn't the court acting all alone, but the court decided a case, this gender line is no good. State legislatures, the U.S. Code, the entire U.S. Code was canvassed to identify all of the gender lines in it, and most of them were changed. So it was, the whole political system was moving. The court was putting its stamp of approval on the side of the change. The legislatures were looking at their laws, getting rid of the obsolete ones. It's a very, very healthy way for a democracy to operate when everybody is involved in thinking about change and what is good for the society. So it was hardly that the court should have stayed out of it, but the court in the gender discrimination cases, for example, every year or two came out with another decision that said this gender line is arbitrary. It was that dialogue, the conversation, the different players in the political process were engaged in that I thought was healthy for the system.
Some will argue that a widespread adoption of the techniques we advocate in this book would be to turn back the clock. But we do not propose that all decisions made and doctrine adopted in the past half century or so of unrestrained constitutional improvisation be set aside. We must bow to stare decisis. Close quote. Mr. Justice Scalia, it's not a matter of turning back the clock. It's a matter of restoring the original meaning of the Constitution. You put for 400 pages, you have 400 pages of Mozart, and you end with 2.5 pages of a Bronx cheer. You take it all back. Say it ain't so. Say it ain't so.
Okay, so counsel appears before us in the case, and he's arguing, he's about to argue that a statute enacted by Congress is unconstitutional. But before he gets into it, wait, counsel, now. Do you think we have the power to ignore a statute enacted by Congress simply because, in our view, it's unconstitutional? He says, oh, yes, Your Honor, you know, Marbury versus Madison. I know, Marbury, but was it right? Let's rethink that. You can't run a legal system that way, reinvent the wheel every time you have a new case. You have to accept, you know, water over the dam. And that's what stare decisis is all about.
Stare decisis is Latin for water over the dam.
That's what it is Latin for, right.
Okay. So, but then you provide these criteria for deciding whether stare decisis should rule. And the criteria are just as vague as the criteria that Judge Posner might impose in reading looking for legislative intent. Is it settled law? Have people arranged their lives around it and so forth? This is all in the afterword.
Yeah,
no?
Number one, the number of items to which this vagueness applies is much less than the number of items to which Judge Posner's vagueness applies. I mean, you know, the world is his oyster. Any statute can be interpreted to do what it ought to do. But secondly, I don't think those criteria that I set forth there are so vague. I set forth three that I employ. Number one, how wrong was it? Was it blatantly wrong? Some of them are maliciously wrong. They must have known they were lying. Okay, that's
Plessy's on the books for over a half a century before Brown comes along.
That's just one of my criteria.
All right.
Number two, has it been generally accepted? When I was in law school, the incorporation doctrine was still controversial, whether the 14th Amendment had the effect of applying the Bill of Rights to the states. It didn't used to apply to the states. But it's been accepted for half a century now, and it's no big deal. Number three, compare that with Roe versus Wade,
right,
which was controversial when adopted and remained so. And apply the first criterion to Roe versus Wade. You know, how bad was it? Even the people that liked the outcome acknowledge that it was a lousy opinion. Third factor, and for me the most important really, can I work with this case as a lawyer? And again, the best example is Roe versus Wade. I don't know how to do Roe versus Wade. I'm supposed to say, does this particular state statute place an undue burden on the woman's constitutional right? How do I know whether it places none? I'm a lawyer. I would normally run to the law books and see, you know, what do you know? For 200 years, no burden was an undue burden. You could forbid it. This is a policy judgment. I mean, you have a statute that requires so many doctors, so many nurses, so much expensive equipment, and it raises the price of abortion. And the issue for my court will be, does this place an undue burden? What am I supposed to do with that as a lawyer? You think we're going to talk about law? We're not going to talk about law. We're going to say, I don't think that's an undue. Do you think it's an undue burden? How many things? I mean, 5 hands it is, 4 it isn't. I'm not going to do that. But, you know, those are my 3 criteria. I don't think they're very vague at all. And when I find that they strike out on all 3, I don't adhere to the prior case.
Take the worst case scenario. Suppose this court, which is precedent bound, and has already once said in the Casey case that Roe v. Wade is the precedent and we're going to adhere to it. But take the worst case. Suppose the decision were overruled. You will have a number of states that will never go back to the way it was. And then again, it will be a question of, is access available in the United States? Yes, it is. Any woman who is fortunate enough to be living in one of those states, or any woman who can travel to those states. Frankly, who it leaves out are poor women. So if you have the sophistication, the money, you are going to have some place in the United States where your choice can be exercised in a safe manner. But if you don't have the wherewithal, then you may be stuck. And that would be the situation in the United States if the court were to turn around on Roe v. Wade. It would mean that poor women have no choice. And that doesn't make much sense, I think, as a matter of national policy.
I'm speaking about who in a democratic society should have the power to determine the government's view, the law's view of what the natural law is. And that seems to me obvious. Given that there is a natural law, the question becomes, what do the American people or the British people or the Dutch people believe the natural law to be? Does it permit abortion or forbid abortion? And in an open democratic society, the people can debate these issues and seek to persuade one another to their point of view. And the people, unlike the courts, can even compromise on these issues. For example, by leaving the issue of abortion to be dealt with in divergent fashion by the subunits of a federal state, or by prohibiting only abortion performed in a particularly brutal manner, or by permitting abortion only in case of rape or incest.
I mean, think of how the Warren Court was criticized for being activist even in their main decisions, which is absolutely accepted now, that main decision that was Brown versus Board. And, you know, if you look at it now, you say, my goodness, what could have been more literal? The Constitution says equal protection of the law. It says every citizen is entitled to equal protection of the law. And you simply had to, I'm old enough to remember, you know, and you are too, when throughout large portions of this country, you know, vast numbers of citizens of the United States of America were just treated unequally. That really understates it. They were treated really badly. And anyone who went around and opened his eyes could just look and say, you call that equal protection of the law? Of course it isn't. And what the Warren Court did then was simply say those words of the Constitution in the 14th Amendment, which was aimed to take people at that time in the 1870s who'd been slaves and integrate them into American society, that it was designed to do that, and the words said it, and my goodness, it wasn't being done. And there, I think that was literal and purposive and historical, anything you want to say. And yet at the time, people said who were opposed to that, oh, this is very activist. Well, of course, it wasn't in any sense whatsoever. So beware of labels.
One of the things about your Constitution you can ask is, how does it evolve? Do we have some prejudices now that we can't see? Is there some injustice now that we're blind to? Our parents, Earl Warren, the people that lived in California, were good people, but they had a blindness. Are we blind today to certain things, injustices? That's one of the reasons you read cases.
If you go back to the end of the 18th century and you examine what the founders thought, say about the Commerce Clause, they didn't think of the internet, and they didn't think of television, and they didn't think of the radio or automobiles, etc. But they wrote a value into that clause, and that value is permanent, like the value under the First Amendment is permanent. Free speech is a value that's permanent. But how you apply that to a world where social conditions and physical conditions and every other condition is changing continuously, and how you take a document that applied to 4 million people or so in 1789 and today has to govern a continent of 300 million people of every race, every religion, every point of view. And, you know, with 300 million people, we have 900 million points of view minimum. And how you do that is not obvious. And the Constitution, in the application of it, adapts to the circumstance in order to keep the values the same. Now, that's the kind of thing that underlies that notion, cliche though it is, and I think that which underlies it is certainly valid.
If all you meant by the living Constitution is that the Constitution has to be applied to new circumstances that were not envisioned at the time of its adoption, I wouldn't give it the name living Constitution, but I wouldn't disagree. Of course you have to figure out how the First Amendment applies to new technologies, to radio, to television, and so forth. That's not what the fight is about. The fight is about taking pre-existing technologies, pre-existing realities that were there at the time the Constitution was founded, and changing the answers. I've sat with 3 colleagues, living constitutionalists, who believed the death penalty was unconstitutional. Nothing has changed. No technology alters whether that's a constitutional punishment or not. And yet the living constitutionalist could one day say, because of the new circumstances of our 300 million people, we feel differently about it today than we used to, and therefore I am going to prescribe from the bench that you cannot have the death penalty. That's the kind of thing that I do not agree with in the living Constitution. It applies not just to the death penalty, it applies to abortion. Abortion existed then. Nothing's changed. Nobody thought abortion prohibition of it was unconstitutional. But living constitutionalists say it is. The same thing applies to, prohibition of homosexual conduct. It's not the disposition I'm concerned about. If you want to change things, if these 300 million people want to change things, you don't have to use the Constitution to do it. Use the legislature. That's what we do in a democracy. And it's very undemocratic for the court to say, make the change.
I'm a judge, and my job is to interpret the law and to apply the law. Now, that's often a hard task, right? Because it is often the case, at least the cases that come to the Supreme Court, which are, the hardest cases, where the law is unclear. It's ambiguous in some kind of way. There's some kind of gap, which makes it not crystal clear exactly what the law is. But it's really important that in resolving that ambiguity or in filling that gap, that what you not do is import your own thoughts about
what would make for a good society. So think about it first. I mean, our cases fall in two groups, generally. One is statutory cases and one is constitutional cases. So think of a case where Congress writes a statute and Congress has not expressed itself clearly as to some matter. And the question is, how do we interpret and apply the statute when Congress has not given the world's most lucid instructions? And there are lots of different approaches to that, but one very bad approach would be for me to say, well, what would be the statute I would like to write? What do I think a good statute would be? What do I think the real problem? That's a terrible way, all right? So now there are different views about how you deal with ambiguity in a statute. Some people just say, I'm going to look only to the text, and I'm going to get everything I can from the text, but I'm not going to, and I'm not going to go any further, even if that leaves, even if I know that even if I feel as though the text doesn't completely answer it, that's the only place I'm going to look. Other people will look to legislative history. Other people will try to explore legislative purpose. There are a whole number, other people will use what are called canons of statutory, but there are a whole number of interpretive techniques to try to figure out what Congress meant. And people will disagree about which techniques to use, and sometimes people will disagree about the application of those techniques. But I think what none of us do is to say, well, who cares about what Congress thought? Congress has not spoken very clearly, so I have the ability to write a statute of my own. That's not my job. And I have to know what's my job and what's somebody else's job and have a very clear separation between those two. The same is true with constitutional interpretation. Constitutional interpretation is often really hard. I mean, what does it mean to make no law abridging the freedom of speech? What's an abridgment? What actually is the freedom of speech? What does that allow and what doesn't it allow? What does equal protection of the laws mean? Now, those we see cases that force us to say, here's this constitutional language. How does it apply to a particular case? And again, there are different methods of doing constitutional interpretation, different emphases that people give to texts, to history, to precedent, and so forth. But one thing that would be completely wrong would be to say, well, here's my view of the perfect Constitution, or here's my view of justice, justice. That's not the task. The task is to try to give the best reading possible to the Constitution, just as much of law as a statute, just like you wouldn't make up your own statute. You can't make the Constitution mean whatever you might think the best Constitution would mean, right?
I did want to ask you, though, about your approach to writing separately. You do write separately quite a bit.
Oh, I do?
Yeah, you do. And you really forge your own path in those separate opinions. And just this past term, for example, one of your separate opinions on the application of the Sixth Amendment to the jury trial right, the Aileen case, to sentencing facts, became the majority view of the court. But others of your separate opinions may be less likely to command a majority view anytime soon.
Maybe like a fine wine, it just needs aging.
Is that your philosophy of separate opinion writing?
Hey, Harlan, it took him 60 years, and he eventually won in Plessy.
Mm-hmm.
I just, you ask a very good question. I think that I may lose, but I think I'm obligated, in fact, encouraged by my colleagues that if you believe that, you write it. I try not to do it in a way that's not polite or respectful, but I think that someone should have kept writing that segregation was wrong. Regardless of what the precedent was, that I think you have to say certain things.